Hi, it's me, Shireen Smith from the Legally Branded Show to talk about IP limitations. Now, Google is an example of a company that's built itself into one of the largest brands on earth, thanks in many respects to its intellectual property. Its brand was worth $100 billion in 2017. So its IP includes its search algorithm, know-how, patents, copyrights, and its trademarks, of course. A highly important component of Google's IP is know-how, which is kept confidential so that users have difficulty gaming the system. Otherwise, Google's reliability as a search engine would be hugely damaged if inappropriate websites were readily able to appear prominently in search results. The less relevant a search result is when a user searches for something, then the less likely they would be to turn to Google next time they needed to do search for anything, really. So a lot hangs on keeping its methodology and other secrets to itself, and even making changes every so often to keep people guessing and its algorithm fresh. So confidentiality and other intellectual property rights play a big part in Google's business, as they do in yours and mine too. So IP rights need to be considered carefully when starting, growing, or exiting a business. It helps to understand its limitations as well. So let's consider this now. Protection of ideas. As I've mentioned before, the only way in which intellectual property rights protect ideas is if they're kept secret or revealed to others under a context of confidentiality, such as by having someone sign a confidentiality agreement before you disclose your ideas to them. Once you let the world know your ideas, such as by publishing them, then the law will protect the way you've expressed your ideas rather than the actual ideas themselves. What this means is that third parties can learn from you. They can write their own articles using your ideas. Your copyright wouldn't be infringed unless they copied and pasted your writing. But they can freely use your ideas, and they don't even need to credit you with having had those ideas first. So we live in a world where the prevailing philosophy is to publish and spread your ideas to profit from them. So it's really important to be aware that by sharing your ideas, you do increase the risk of others pinching what's yours, be it an invention, a product idea, your business model, or simply your insights, and they could then profit from them, possibly at your expense. Business is a long journey of learning. Intellectual property is business. Understanding it helps you to better assess how, when, and whether to reveal your ideas or to tell everyone about your processes. An important aspect of developing your commercial awareness is all about understanding IP and its limitations. So when you're spreading your ideas, aim to get exposure without seriously disadvantaging yourself. Generally, this means allowing yourself sufficient lead time to bring your ideas to fruition before revealing them. This is so important to understand as a limitation of IP rights, because it will help you to protect your business and to realize that it's often not possible to do anything about it if somebody copies the idea behind your business or your blog or whatever. Copying business models. Steve Smith and David Dodds made a lot of money out of Poundland, and since it began operating in 1990, but they couldn't prevent Nadir Lanani from subsequently establishing his 99p stores, selling everything in store for 99p. It's fundamentally the same idea, selling everything for £1, but it's a different expression of that idea. In fact, Poundland ultimately decided that the best way to deal with the 99p stores chain was to buy it and then close it down. The more lucrative a new service or sector proves to be, the more you should actually expect extreme competition to quickly follow if you're first to launch your product or service. I mean, Uber quickly spawned dozens of copycat apps and services, as did Airbnb. It's impossible for anyone to keep a profitable niche to themselves. It's the same in the low-cost air travel field. EasyJet was founded in 1995. It essentially operates the same business model as Ryanair, which began its low-cost model 3 years earlier. And Ryanair has always been honest that it copied the model pioneered by Southwest Airlines, which leads me to another limitation of intellectual property rights, and that's that they're primarily limited by geography. They're territorial in nature. So while you may have a patent or a trademark in one country, unless you've also registered it in another country, it's likely that you wouldn't be able to prevent somebody from using that trademark or your patent in a different jurisdiction. However, it is possible to register a trademark that provides protection in a range of countries, such as in all 28 EU countries. There's a lot of money to be made, really, in exploiting these limitations. Venture capitalists often invest in startups which take an established business model and adapt it to an emerging market. Successful examples include Pexe Urbano, a Brazilian group, Weibo, the Chinese Twitter-like micro-blogging platform, and of course Alibaba, a Chinese eBay. Alibaba is now one of the world's largest online businesses. Projects like this are really attractive to investors because the business model has already been proven, though the clones often refine the model based on the experiences of the original business and the local circumstances too. That original business has little recourse, even if it wanted to object to the copying, essentially. Copyright does provide powerful protection due to international treaties such as Berne Convention, which many countries have signed up to. It means that writers, musicians, software developers, and other creators of copyright works, including ordinary businesses like yours or mine, enjoy copyright protection worldwide, even without registering copyright in a particular country. So it's possible to become too successful where intellectual property is concerned, and that's the subject of genericity. When you clean the house, do you hoover the carpet? Do you write notes using a biro? How often have you used a cache point or Googled a query? Not all vacuum cleaners are made by the Hoover Company. Not all ballpoint pens are Bic biros. Not every ATM is a cache point operated by Lloyds Bank. Not every online search is in Google. So basically, vacuum cleaners became synonymous with Hoover People talk of biros regardless of the particular brand of ballpoint pen. A cash point is what many people instinctively call a hole in the wall. So by becoming so closely associated with a widely popular product or service, the trademark means it's in danger of losing its distinctiveness and therefore ceasing to be registrable. Google, for example, is often used as a verb, and it's taken steps to avert this by using Google as a descriptor in its product names. This probably explains why it rebranded Picasa in favor of Google Photos, Blogger in favor of Google Blogs a few years ago. It also uses Google in front of services, for example, Google News, Google Image Search, and so on. You know, people can't use Google as a verb when it's combined with those descriptors, so it actually helps Google to show that the word Google is being used widely as a noun in this way. If Google couldn't establish that people do use the name as a trademark, then the fact that people regularly employ its name as a verb would endanger its trademark. So Google's domination of search engine results has endangered its distinctiveness, even though the word is a made-up term. For now, at least, it seems Google is taking active steps to avoid genericity of its name. The benefit of relying on a range of IP rights, if you hold a wide portfolio, is that your business model will be better protected against copying. For example, a patent can sometimes protect the technology which is central to a product. Copyright can protect the expression of a concept, such as training and marketing materials, videos and source code, and other key components of your intellectual property. Design can protect the aesthetic aspect of your products, and trademarks can protect your product names as well as your logo. So the combination of all these IP rights, all protecting elements, provides stronger protection than focusing on a single one or two IP rights. Each IP right protects you in subtly different ways and situations, so that it makes it more difficult for others to rip off what's yours and copy your business model in its entirety. So don't assume that it's enough to have a patent. You almost certainly still need to find a good name for your business or product, and also consider whether you've protected your copyright in the best possible way. Sadly, it's only when something happens in your business that you'll know which of the IP rights will be most useful to rely on to address the situation. The only way to be well protected is to use all the available IP rights. For example, if someone copies your logo but isn't making commercial use of it, a registered trademark will be of limited use. Copyright could help, but even better, if you've registered your logo as a design, this would make it far easier for you to cost-effectively address the situation. Now, databases and other IP rights are important assets for many businesses. You know, your customer database is protected through database right in the EU at least. A quick and easy way, like adding a false name and address to your database, could actually save you thousands of pounds should you ever need to prove that your database has been copied by someone. It's also really important to put in place appropriate contracts. employment agreements, terms of business, confidentiality or non-disclosure. All these agreements, to name a few, supplement your IP protection and in some cases are the only way to protect your position. These are the limitations of IP that you would be overcoming by using NDAs to protect your confidential information. But don't actually take too much comfort from an NDA, because if you talk to others, only do so if you really need to involve them. And if you're using them to develop a prototype, then you're going to need other contractual provisions too. Various restrictions are appropriate to have in these agreements, not just the requirement to maintain confidentiality. For example, you may want to restrict web designers from outsourcing or subcontracting the work if the reason for the NDA is to start having a website built. So if you've written a document containing sensitive information, disclosing that document to a third party under an obligation of confidentiality increases your protection, because you then potentially have both copyright infringement and breach of confidence, depending on what happens in the future to stop any undesirable use of your confidential information. But if you have a potentially lucrative idea, best not to tell anyone about it unless it's essential to do so. There are limits to what IP can achieve, but the law is there to protect you if you understand its limitations and the legal process. Then you're going to have a real advantage in commercial life. Generally, going to court is not a positive experience, even for the winning party. Both sides in a court battle lose out on many levels, as the time it takes up apart from anything else. So it's far better to avoid the need to sue or the risk of being sued by someone, although sometimes it's just not possible if you're up against somebody litigious and unreasonable. So really, aim to do proper due diligence before you lay claim to an IP right, and then once you've done so, secure your rights rather than relying on common law rights, such as use of a trademark. Like that, you're much more likely to deter copycats, because savvy business people will take notes of your rights rather than infringing them. Therefore, the common myth that it's not worth securing IP rights if you can't afford to go to court to defend them is wrong. IP protection has many limitations, but never use this as a reason to justify not securing any IP protection at all. I started this talk talking about Google. Certainly it's unique, it's a unicorn, and you and I will probably never get anywhere near the success that Google has enjoyed. But we're all in this entrepreneurial journey for a reason. We may want to create transformation to effect a change in the world, perhaps, in our own small ways. So developing an understanding of key intellectual property principles will help you reach your aims. The knowledge and skills that you'll gain will enable you to be more commercially savvy. Find out how the Legally Branded Academy can help you quickly develop the IP skills and knowledge that you need in your business. That's it for today. Bye.